Will the Senate please come to order? We'll observe a moment of silence in lieu of a devotional. Thank you. Are there any announcements? Seeing none, orders of the day. We have 542, H 542 for third reading. Are there any amendments to be offered prior to third reading? Seeing none, listen to the third reading of the bill.
H 542, an act relating to terminating testing of schools in Vermont for polychlorinated biphenyls.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we've passed H 542. We now have H 710 for third reading. Are there any amendments to be offered prior to third reading? Seeing none, listen to the third reading of the bill.
H 710, an act relating to defining electricity generating facilities.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. No. The ayes appear to have it. The ayes do have it. We passed H 710. We have on the calendar for action H 294, introduced on February 20th of 2025. It was referred to the Committee on Institutions, which reports it has considered the bill and recommends that it ought to pass in concurrence. Listen to the second reading of the bill.
H 294, an act relating to telecommunications services and wages in correctional facilities.
I recognize the Senator from Windsor, Senator Major, for the report of the Committee on Institutions.
Thank you, Mr. President. H 294, an act relating to telecommunications services and wages in correctional facilities. At its core, this legislation is about rehabilitation, public safety, and strengthening the human connections that help individuals successfully return to our communities. The bill begins by clearly stating the intent of the General Assembly to create conditions beginning to incarceration that encourages rehabilitation, reduces unnecessary barriers to communication with loved ones, and divest Vermont from resilience on the for-profit prison industry, and ensure future correctional policy decisions are guided by data and careful analysis. H 294 does not immediately mandate sweeping operational changes. Instead, it directs the Department of Corrections to conduct thorough evaluations and provide detailed reports to the legislature so that future decisions are informed, fiscally responsible, and transparent. Under Section 2, the Department of Corrections is tasked with evaluating options for providing no-cost telecommunication services to incarcerated Vermonters. The report, due by December 1st of 2026, will examine the state's current telecommunication model, include cost, usage rates, and existing contracts. It will also evaluate alternatives such as nonprofit service providers or regulated utility systems. Importantly, the department must analyze both the fiscal and operational implications of these alternatives. That will include startup transitions, costs, ongoing operational expenses, impacts on the department's budget, and potential changes in usage volume. The evaluation must also examine broader impacts on institutional behavior, facility safety and security, and an incarcerated individual's ability to maintain critical support systems outside of prison walls. The bill must also require broad stakeholder engagement in this process. The department is directed to consult with the Public Utility Commission, the Joint Fiscal Office, nonprofit providers, correctional experts, reentry organizations, families of incarcerated Vermonters, formerly incarcerated individuals, and other relevant stakeholders. Draft reports will additionally be reviewed by the Joint Legislative Justice Oversight Committee to ensure legislative oversight and input throughout the process. Section 3 addresses inmate wages and directs the department to evaluate the impacts of current compensation levels within correctional facilities. This report will collect and analyze existing wage structures and identify labor currently performed by inmates that would otherwise require state employees or private contractors. The department must also evaluate how different wage scenarios could affect outcomes such as maintaining family relationships, meeting restitution and support obligations, and successfully reentry into society and participating in work programs. In addition, the report will assess relationships between inmate wages and the ability to afford telecommunication services and commissary items. Mr. President, this legislation recognizes a simple but important truth. Maintaining family and community connections reduces isolation, improves rehabilitation outcomes, and ultimately contributes to a safer community. It also acknowledges that if we expect incarcerated individuals to prepare for successful reentry, we must examine whether the systems we have put in place support that goal. H.2 94 is deliberate, measured, and data-driven. It does not presume conclusions before the analysis is complete. Instead, it asks the state to carefully evaluate costs, operational realities, and long-term outcomes before making future policy decisions. I would like to thank the members of my committee, the Institution Committee, the Department of Corrections, advocacy organizations, and all stakeholders who contributed to the testimony and expertise throughout this development of this legislation. That is to include the CEO of Emilio, a telecommunication act, the Legislative Council, the presenter of the bill, the Department of Corrections as well. The vote in committee was 5-0-0, and Mr. President, I respectfully ask that the Senate support H.2 94.
The question is, shall the bill be read a third time? Senator from Chittenden.
Thank you, Mr. President. May I inquire of the presenter of the bill?
The presenter's interrogated.
Thank you, Mr. President. I notice in the list of stakeholders for communications listed is CoreCivic, one of the largest for-profit prison entities in the country. And to my knowledge, we only have state-run facilities, so I'm a little confused why CoreCivic would be asked to consult in our system.
I think it's important to get all stakeholders, even though they're not currently in our, they may know something that we have not thought of. So all stakeholders on all prison systems, I think, are important, even though they are not in this current prison system.
I thank the presenter. I am fairly concerned. CoreCivic's goal is to make a profit, and I don't think that we should be engaging in making profit off of locking people up. So it is a little concerning to me that we are including them in discussion of anything related to incarceration. I may connect with the committee in the interim to talk a little bit more about it, though. Thank you.
Are you ready for the question? Senator from Franklin.
Thank you, Mr. President. May I interrogate the presenter of the bill?
Presenter's interrogated.
Mr. President, I see that they took testimony from DOC. I was just curious, on page 4, where it says collects and analyzes on line 3 the current wage levels for inmate. Was there any testimony offered as to what they are presently making? Is it the same throughout the state, or I guess I'm just curious about that.
We did take testimony, and I would have to get back to you with third reading to find out what exactly that was, because I don't have that with him, but we did take that testimony, what they are exactly making. It is standard throughout the state.
Thank you, Senator. I would like to have a third reading, yes. Thank you. Thank you, President.
Are you ready for the question? The question is, shall the bill be read a third time? If so, all in favor, say aye.
Aye.
All opposed, nay. The ayes have it, and you've ordered third reading of H 294. We have on the calendar for action H 567, introduced on January 6th of 2026. It was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that it ought to pass in concurrence. Affecting the revenues of the state, the bill was referred to the Committee on Finance, which recommends that it ought to pass in concurrence with proposal of amendment as found in today's calendar on page 4422. Affecting the appropriations of the state, the bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass in concurrence without proposal of amendment as offered by the Committee on Finance. Listen to the second reading of the bill.
H 567, an act relating to unclaimed property, state retirement systems, and capital debt.
Recognize the senator from Windsor, Senator White, for the report of the Committee on Government Operations.
Unclaimed property. An exciting thing to hear that you have, because that means you potentially are owed money that is rightfully yours, that you are getting information about from the treasurer's office. That could be a windfall, that could be a small amount of pocket change, whatever it is. If you're interested in the topic of unclaimed property, retirement and OPEB, the Vermont Saves Project program, or our Capital Debt Affordability Advisory Committee, then I would recommend you listen closely to my bill presentation of H 567. I'm going to go through a narrative of those four major themed programs, and then I'll do a brief section by section. This is the Treasurer's Omnibus Bill, and it came to us largely directly from the Treasurer. We, as the Senate Government Operations Committee, did not articulate any changes, and you will see in subsequent reports a little back and forth on if that's the right call with different amendments. But let's start first with that unclaimed property I noted at the beginning. The Bill 567 raises the threshold for various processes related to returning unclaimed property to account for inflation. These changes will make it easier for Vermonters to claim their unclaimed property, especially in cases where the original owner is deceased or where the unclaimed property is a medical insurance payment. The other piece to this bill includes the retirement and OPEB system, if you know that acronym. This bill takes two important steps to strengthen the retirement system, and it includes two more, administrative changes as well. First, it establishes a pension and benefits funding task force to review funding and amortization policies from the pension and OPEB systems. As the state approaches full funding of these systems in 2038, thanks to us and laws we passed in the past, the risk of volatility in annual state payments, that increases. This task force will examine options for mitigating that volatility and look at best practices in the systems nationwide. It will not consider benefit levels or contribution rates, so if you're worried about that, don't worry. And the recommendations will be presented before the start of the next biennium. Second, this bill moves the responsibility for the investment of other post-employment benefits, that OPEB acronym, and funds from the Treasurer's Office to VPIC. So if you're following along, we're talking retirement and pensions. These funds, which primarily go to fund retiree health insurance benefits, have grown dramatically since the state began pre-funding them through Act 114 of 2022. This change follows fiduciary best practices by establishing a commission rather than a single individual as the investment fiduciary. It also aligns the investments of OPEB assets with the pension assets, leveraging VPIC's expertise and the economies of scale to provide overall benefit for both funds. So win, win, win for everybody. And finally, this bill makes two smaller changes, those administrative changes I noted. It aligns the enforcement language for entities that fail to pay the employer share of pension costs across all our pension systems. This language was currently absent in the state system, which despite its name includes a small number of towns, and also sheriff's offices. It also allows for members of the teachers and municipal systems to purchase service for time spent as president of a bargaining unit with full release from service. So that's an important piece. You can probably all think of that exact person in your life who does that right now in your community. They work on a board after retirement. Service purchases are calculated by actuarially neutral, are calculated to be actuarially neutral to the systems, so there's no cost to the state. So we've covered unclaimed property, we've covered the retirement piece. Another section to this bill that you'll see is the Vermont Saves work. So we know 3 years ago, the legislature established Vermont Saves. If you weren't here then, or you don't remember your vote, that's a public retirement savings options for Vermonters whose employers do not offer retirement benefits. I know that this has personally benefited so many of my constituents who did not have access to retirement benefits, but were noticing over time that they were not able to privately save or find an alternative private market solution. So instead of investing, they weren't investing and they had no retirement savings. So this program is extremely beneficial. And the program has been a success, with over 6,000 Vermonters collectively saving more than $7 million to date. That's $7 million more than we're being saved towards Vermonters' retirement, helping us both as a state and those people as individuals. The program was initially funded with a much smaller appropriation than similar programs in other states, and has not yet reached the point of being fully self-funded. This bill includes a provision to support the program until it becomes fully self-funded by FY33. The proposal will not impact the general fund, and will boost funding to the Higher Education Endowment Trust Fund, all while supporting the Vermont Saves program to the point of self-sustainability. To achieve this, the bill would allow the treasurer to expand an existing unclaimed property transfer that currently goes to the Higher Education Endowment Trust Fund and temporarily divert a portion of that larger transfer to fund Vermont Saves. As a result, the Vermont Saves program will continue, and the Higher Ed Endowment Trust Fund will see an increase in revenue over the duration of the provision. The last portion of this bill is related to our Capital Debt Affordability Advisory Committee, CDAC, which we've actually heard on the floor recently about. This bill contains some minor technical changes to the CDAC statute, and these changes do not represent a policy shift, but align statutory language with the CDAC committee's recommendations. Your Committee on Government Operations voted this out favorable with a 5-0-0 vote. Our witness list included the Treasurer's Office, members of the the Pension and Benefits Task Force, VPIC, and Legislative Council. I'm going to spare you the section by section, and I will thank you for your interest in this bill, and ideally you will vote for it alongside the Committee on Senate Government Operations. And if you want more information, I have with me multiple presentations that we received with the hard numbers to explain the points I made. So if you want the hard numbers on how we're keeping those funds sustainably funded, or you want more specific information, I can provide to you that information, but it's pretty detailed, so I didn't want to hand out multiple OPEB reports to everyone. So thank you for listening, and I have that documentation here if folks have questions.
I recognize the senator from Addison, Senator Hardy, for the report of the Committee on Finance.
Thank you, Mr. President. Could I have a brief recess, please?
We will take a brief recess. Will the Senate please come to order? Senator from Addison.
Thank you, Mr. President. I appreciate the time to sort out our situation here. But I'm going to give the Finance Committee report. The senator from Windsor did such an excellent job with the report on the bill that I don't have to add that much. But the Finance Committee did look at the impact on the revenues of the state, particularly with the increase from $100 to $150 as unclaimed property amounts that would be deposited into the Higher Education Trust Fund and then transferred to a fund to help support the Vermont Saves program. This would redirect up to $300,000 annually from the trust fund to the Retirement Security Fund, beginning in fiscal year 27 until January of 2040. The trust fund may still receive contributions from this funding source, provided that no more than $300,000 in total is transferred to the two funds combined. It is expected that over time, the trust fund will receive more contributions from unclaimed property than under current law because of the increase from 100 to 150, because 150 is more than 100. The treasurer expects that the Vermont Saves program will scale up to be financially sufficient from the program fees by fiscal year 2033. That is all about the fiscal impact. The Finance Committee was fine with that. We felt like that was a reasonable compromise between the two funds and the amount of the transfer. We also included an amendment, Mr. President, about the Higher Education Trust Fund. The body may recall conversations earlier in the session about the use of this fund, and so the Finance Committee thought it was important to provide a report about the use of the fund, including mechanisms. And this report would be done by the state treasurer, and the treasurer would be required to consult with the members of the trust fund themselves, which are the presidents of the institutions whose students receive the scholarships, so UVM, the Vermont State Colleges, and VSAC. The treasurer would also be required to consult with the student organizations in those institutions to make sure that the students are involved in the conversation about the report and the use of the funds, since they themselves are the beneficiaries of the scholarships from the Vermont Higher Education Trust Funds. And then the treasurer would make recommendations on mechanisms, including requiring consultation with the Vermont Higher Education Trust Fund Council for ensuring appropriate fiduciary oversight of the use of the trust fund to ensure that the endowed funds, including principal and interest earnings, are available for the intended purpose of providing scholarship to Vermont students. Also, how to expand or modify the membership of the council to include student representatives of the recipients of institutions of higher education, and how to expand the scope of scholarship awards, including award amounts, types of degrees covered, and the institutions of higher education included in the scholarship program. Again, the treasurer would be required to consult with the council and the student organizations. And this is just to make sure that this endowed fund is preserved for scholarships for students in the wake of all of these maneuverings around to try to use the fund for different purposes. So the committee voted unanimously to accept this amendment to the bill requiring this report. However, Mr. President, at this time, I would actually like to withdraw the amendment of the Finance Committee. This report is going to be combined with another report from the other body in the big bill. So it is no longer needed in this this bill. So without objection, Mr. President, I would like to withdraw the finance report.
Without objection, we will consider it withdrawn. Senator from Washington for the report of the Committee on Appropriations.
Thank you, Mr. President. Thanks for the Finance Committee for making that kind of last minute change, but this will help us to grease the skids to get to adjournment just a little bit quicker. If we can just pass it without an amendment to the House version, since that study was the only difference from the House study. And we are going to add that, combine that with the other study that's in the big bill coming over from the other body, which deals with the higher ed trust funds. The two studies were similar but different, so we're going to combine the two for a more comprehensive study. There are some fiscal impacts to this that affect the general fund, despite the assurances from the senator from Windsor and the assurances from the treasurer. He kept saying this, or the treasurer's office kept saying that. In particular, the unclaimed property, moving the money to the Vermont Saves program, which we support and want to see successful. Because any unclaimed property after a certain time goes to the general fund. It reverts to the general fund. So if there's less money in the unclaimed property fund, because it's going to the Vermont Saves, that's going to be less money coming to the general fund. So there is an indirect impact on the general fund. However, there's been more money going into the unclaimed property fund. They think it's going to be increasing. So on net, it might not be a difference, but there is going to be an impact for the next few years where they're going to be taking this to the Vermont Saves. This $300,000 a year could end up in the general fund. So we had a lot of discussions about that. In the end, we were okay with it, passed it. I think it was unanimous. I forgot to look at that vote. But the other two things in the bill that you already heard about from the other two reports, the pensions and benefits funding task force, that's about $75,000 in costs that the treasurer's office anticipated for that task force. We have that money is not in the bill, it's in the budget. So that the treasurer will have money to account for the administrative costs of the task force. And the third one is the OPEB change that you had. There is a cost that's going to be borne by the pension fund. It's about $270,000 a year per position and other admin costs to move it over. There's some savings in the treasurer's office because the treasurer's office is doing this work now, but they didn't have a full-time position. But given the increase of the amount of money in the OPEB fund and the importance, it made more sense to have a professional staff person doing that. So we thought it was money well spent. So that's the appropriations report. I did get a note that it was a 7-0 vote on the bill. Thanks.
So the question is, shall the bill be read a third time? Senator from Rutland.
Thank you, Mr. President. If I may interrogate the presenter of the bill from Government Operations.
The presenter is interrogated.
So first, I'd like to show appreciation for the good work of the Government Operations Committee. Vermont Saves is a great concept, 100% supportive of the program. The key to personal self-sufficiency really is savings. So this reinforces that notion. But my question is, we started the program roughly in 2023. We're looking, according to the reporter's comments, we appear to be heading towards self-sufficiency somewhere around 2033. Mr. President, would that be correct?
Yes.
Okay. So my question really is, Mr. President, is the 10-year ramp up to self-sufficiency for Vermont Saves, was that the original plan? Was that the original concept and timeline for self-sufficiency?
I thank you for that question. I think the question is pertaining to a previous bill that we passed on asking what the construction was within that bill. And I don't remember if we described in the original creation when we signed it. But I do have the funding for the Vermont Saves program self-sufficiency projections, which do show us hitting it just barely at around 2032. We only have a $10,000 difference between being self-sufficient and 2032. So if folks want to kind of see how that ramp up occurs, I'm not sure if we had set the date of 2033, knowing the exact numbers that we're supposed to go in each year.
So, thank you, Mr. President. And I believe, not quite done yet. Thank you. I believe that the reporter outlined that the fund currently has roughly participants that sum up to about $7 million. Would that be correct, Mr. President?
Yes, Vermonters have so far utilized the program to save $7 million. Okay. And that's around 6,000 people.
Okay, thank you, Mr. President. And I'm wondering if we're experiencing a longer ramp up because we're having an enrollment problem, and if there's any kind of feedback that the reporter could give on what we're doing to try to increase enrollment in the project in Vermont Saves such that we get to self-sufficiency either on time, as originally outlined, or accelerating the current experience to hit self-sufficiency prior to 2032.
Yes, we did hear some testimony from the treasurer's office related to the success of the program and if they were not seeing the uptake that they expected, and that would be inaccurate. They are seeing the type of uptake that we expected. The program is not failing or not gaining enough people. That's not the reason for the lack of self-sufficiency. The program is not doing unwell because there's not enough participants, which I think is kind of the underlying concern you may be raising in your question. So I would just say that that's not what's driving this. It's been extremely successful. The second part of your question, I think, is can we up the timeline to get to self-sufficiency sooner by even going beyond that, by getting more people to participate? And I don't recall what the treasurer's office described to us related to any marketing efforts or kind of internal promotion, but I'm happy to get back to the senator on third reading if there's like a marketing budget or how that all is promoted in the treasurer's budget.
Thank you, Mr. President. And one last question, if I could. I'm wondering what the cost to the state is per year for the program while we ramp up towards self-sufficiency.
The VT Saves revenue is around, did you say for this year?
Per year, cost per year until we gain self-sufficiency. What is the cost to the state?
I would be happy to put forward the chart because it changes every year based on the Vermont State Saves Program revenue and the unclaimed property amount is proposed in the bill. And if I'm understanding correctly, you want to understand what the breakout is over that time. So I can read you the numbers, but they don't totally, like they're easier to see on the chart. But in 2027, there's $300,000 of projected money for the savings program. 369 of that comes from, in this proposal, unclaimed property, and then 57,631 comes from Vermont Saves Program revenue. So I guess I can go through each of those. It's like a pink chart at the top, and then a little green chart, and then over time more green.
Thank you, Mr. President. Perhaps if the reporter could copy and distribute the
Yeah,
chart she's referring to it at some point in the future to you, appreciative. And I thank the senator and I thank Mr. President. Good program. Just curious about this ramp up towards self-sufficiency. I didn't know it had such a long tail to it. Thank you, Mr. President.
Are you ready for the question? Senator from Addison.
Thank you, Mr. President. I can just add a little bit of information because I have the fiscal note, which I'm happy to share with the senator from Rutland after. The Act 43, which we passed in 2023, provided an initial appropriation for one-time startup funds of $750,000. That was for FY24 to start up the program, and it hasn't received any appropriations since then. As has been said, the proposed shift of unclaimed property funds would support it as it continues to scale up. This does have the pink and green chart that the senator from Windsor mentioned. In FY27, there's about 57, the numbers are tiny, yeah, but $57,000 in revenue from the fund, from the program, and then $242,000 of unclaimed property revenue. And then the Vermont Saves revenue increases to about $110,000, and then up to $189,000 and $257,000. So I can show the senator this chart, but it does show the ramp up of revenue from the Vermont Saves program versus what would be coming from the unclaimed property revenue. So it does look like by 2032, it's basically fully funded. Thank you, Mr. President.
Are you ready for the question? The question is, shall the bill be read a third time? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of H 567. I have a conference committee on H 955 to announce. Senator Bongartz, Senator Hardy, and Senator Matos. We have on the calendar Senator from Windsor.
Thank you. I would note that we have two fairly loud blowers on either side of the chamber. I mean, I hope you're lucky enough to have one. We have one here. It's great for circulating the air. It also means that we have to use our diaphragms and really speak up because we all need to hear each other and we have no amplification. Thank you.
Senator from Windsor, are you able to hear me?
Yes.
Excellent. I've not usually been told I'm quiet, so thank you. We have on the calendar for action H772, which was passed by the House on April 1st of 2026, was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears starting on page 4424 of today's calendar, and that with such proposal of amendment, the bill ought to pass. The bill was then referred to the Committee on Economic Development, Housing, and General Affairs, which reports that the bill ought to pass in concurrence with proposal of amendment as recommended by the Committee on Judiciary, with further proposal of amendment as found in today's calendar on page 4436. Affecting the expenditures of the state, the bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass in concurrence with proposal of amendment as recommended by the Committees on Judiciary and Economic Development. Listen to the second reading of the bill.
H772, an act relating to residential rental agreements, eviction procedures, and the creation of the Positive Rental Payment Credit Reporting Pilot Program.
I recognize the Senator from Windham, Senator Hashim, for the report of the Committee on Judiciary.
Thank you, Mr. President. So like most things in my life, this is going to be mildly confusing and unusual, but I'm going to try and mitigate that as much as I can. So H772 came to us from the other body as an expansive bill with about a dozen different sections. Some sections of the bill would be considered economic development policies and others would be considered judiciary policies. Our committee worked on the policies related to the judiciary with a particular focus on the trespass and ejectment sections. Through our committee process, the bill was narrowed down substantially to just 4 judiciary-related policies, with the economic development policies left untouched. Senate Judiciary was then relieved of the bill and it was committed to economic development. As you'll hear in the next report, all of the economic development policies were removed, 2 of the judiciary policies were removed, and the remaining 2 judiciary policies were modified. After that, there'll be an appropriations report, followed by a substitute amendment presented from myself. The purpose, actually, Mr. President, may I speak to the report and the subsequent substitute amendment?
You may.
So the purpose of the substitute amendment will be to restore 2 of the judiciary policies and to incorporate some of the language proposed from economic development. It's my understanding that this is a compromise between the committees, but this is the roadmap that I wanted to lay out for folks before this all starts. So for the judiciary report, the bill we received from the other body initially contains sections related to policies such as how often a landlord could raise rent, serving termination notices through email, protections against retaliatory conduct, being able to charge application fees, and a long list of other policies. And I'm not planning to describe policies that were not in our committee's jurisdiction. Our committee's work focused, again, primarily on notices against trespass, Good Samaritan language, rental agreement bifurcation, and expedited ejectment. I'm going to focus on explaining these policies because everything else has either been struck from the bill or is not in our jurisdiction or both. So section 1 includes definitions and what's known as the Good Samaritan language. The definitions are on page 4424 of today's calendar, and the Good Samaritan language starts on page 4427. This section prohibits a landlord from terminating a rental agreement due to a tenant seeking medical assistance from a drug overdose in the dwelling unit or being the subject of a good faith request for medical assistance due to an overdose or being present at the scene of an overdose. We've had similar language in law since 2013 that protects an individual from criminal charges if 911 is called for medical services due to an overdose. And this underlying policy has been endorsed by law enforcement. Mr. President, may I read a quote from the Colonel of the Vermont State Police?
You may.
In regards to this language, the Colonel stated, quote, "When you are in an emergency situation, we don't want you to hesitate or wonder whether calling 911 is the right thing to do. It is. Saving a life is the most important thing. Those of us in law enforcement want you to know that we are here to help with the health and safety of victims of a drug overdose. We want you to remember that you will not face criminal consequences and you could save your loved one's life," end quote. And that is in response to the language that was, to the law that was passed in 2013, the Good Samaritan language from 2013. This section would also prohibit a landlord from terminating a rental agreement of a tenant who is the victim of domestic abuse, sexual assault, or stalking. Section 1A begins on page 4427. This is the bifurcation section. This section would add into statute language governing when a landlord would be required to bifurcate a rental agreement and eject a tenant if the tenant being ejected was committing acts of domestic abuse, sexual assault, or stalking against another victim tenant. A tenant can provide a written request to bifurcate an agreement with or without a copy of a court order. If a court order is provided, the landlord is then required to bifurcate the agreement in order to eject, remove, or terminate a rental agreement. If the tenant who requested the bifurcation is unable to pay rent, the landlord must provide a reasonable opportunity for that tenant to find additional roommates or new housing. A reasonable opportunity is listed as not less than 90 days. So I'll now go on to the trespass section, which begins on page 4429. And this is in section 4, which is a purpose section stating that the intent of the new trespass language is to override a Vermont Supreme Court decision, State versus Dixon, to allow a landlord to trespass a tenant's guests, but there are conditions. This was a case based on a statutory analysis performed by the court. It was not a determination of constitutionality. Section 5 authorizes a landlord to issue a notice against trespass against a tenant's guest if one of the following conditions are met. The tenant consents to the notice, the guest violates the terms of the rental agreement, the guest violates state or federal law while on the property, or the guest has previously been ejected from a dwelling unit on the property due to a termination under 9 BSA 4467 subsection B. This section allows this type of notice to be issued if a former tenant was ejected due to violating the agreement, failing to comply with tenant obligations, criminal activity, illegal drug activity, or acts of violence. Economic Development proposed 2 changes to this section, which I will address later on in the substitute amendment. Regarding the second condition, which I initially had a number of questions about, that second condition I described as if a guest violates the terms of a rental agreement. So I want to provide some additional detail. This is meant in some ways to mirror what we already have in statute under Title 9, VSA 4456, regarding tenant obligations. This current law requires persons on the premises with the tenant's consent to conduct themselves in a manner that will not disturb other tenants' peaceful enjoyment of the premises. It also requires the same guest to not deliberately or negligently destroy, deface, damage, or remove any part of the premises or its fixtures, mechanical systems, or furnitures. The notice against trespass must be issued on an individualized basis. This means that a landlord cannot include in their lease agreement that the tenant automatically consents to the landlord trespassing anyone they want if they're a guest of the tenant. Lastly, the notice against trespass is effective for 1 year and may be renewed for additional 1-year terms. So I'm now going to move on to the Housing Court Study Report, which begins on page 4434. This originally began as an expedited court hearing process section, and our committee spent considerable amounts of time discussing this. As we delved into the topic, concerns arose about logistics, court staffing needs, and tenant due process rights. Ultimately, we agreed to create a study on this topic and have the judiciary report back to us next year about feasibility. And I just want to briefly share my own thoughts on this for a moment and mention that I've heard plenty of times from landlords that they want to be able to resolve their cases faster and that they feel that the court process moves too slowly. And I understand that concern and the desire to expedite a hearing, especially when, from the landlord's perspective, there are significant financial and property interests involved. However, this opens the door to the question of why should these types of cases move more quickly than other types of cases? There's a long list of other types of cases, such as medical malpractice, business contract violations, and negligence cases that directly involve people's personal health, well-being, and livelihoods. These are also urgent cases to resolve. So that, for me, at least, was one of the challenges in opening the door to this question, but I am generally always open to changing my mind and welcome the information that may come back from the report as to how this may work. And that report would be required to come back on January 31st, 2027 to share information related to financial costs, workforce impacts, capacity, and any other relevant matters discovered by the court regarding the establishment of an expedited hearing docket. We heard from the Windham County Sheriff, the State Court Administrator, and the Chief Superior Judge, the Champlain Housing Trust, the Vermont Network Against Sexual and Domestic Violence, the Champlain Valley Office of Economic Opportunity, the sponsor of the bill from the other body, Vermont Legal Aid, and Homelessness Vermont, Housing and Homeless Alliance of Vermont, Legislative Council, and the Vermont Landlord Association. The vote in committee was 5-0-0, and I ask for the Senate support.
Recognize the senator from Windsor, Senator Clarkson, for the report of the Committee on Economic Development.
Thank you, Mr. President. For years, the General Assembly has wrestled with how to improve our landlord-tenant laws. We've heard many of the same stories. Tenants facing sudden displacement with little time and few resources, landlords navigating long, costly processes that make it difficult to address non-payment or dangerous behavior, all of which seemed exacerbated by the COVID pandemic. In 2024, our Senate Economic Development Committee called for a study committee whose task was to review landlord-tenant laws and make recommendations for legislative action. I encourage you all to read it. It's a pretty interesting document and confirms that there are issues on both sides of this challenge. While they didn't get to the recommendations for action, they did do a really good job identifying the problems, and a problem clearly stated is a problem half solved. Identifying the problems, recommending further investigation. What became clear is that the status quo is not working. This bill originally was designed to be a balanced bill, making meaningful progress to a system that all parties agree is falling short. The Senate had less time than the House to weigh all aspects of this important work. And as a result, we have chosen to leave work to advance many of these needed changes to another session. The laws governing landlord-tenant relationship are critically important to get right. These laws establish the rules that guide basic need, access to and enjoyment of shelter and housing, while balancing the need with the rights of property owners. That means thoughtful, incremental approach to changes, and maybe this goes for much of what we do in this building. The reality is that there are real differences of opinions in our committee that by the time this came to us, we had real differences of opinion in our committee and among those who testified before us. Together, we agreed to minimize the changes the House had envisioned as it became clear that we were running out of time and that there was agreement on only in our committee, we had, were under serious pressure to get this bill out. We were beyond our time that the pro tem had given the morning committees, and we were in shutdown mode, and we needed to get this bill out. And so we got to at least agreement on two critical pieces of the bill as it was amended by the Senate Judiciary. And so we move forward to pass the bill out of the committee to ensure that those pieces could be put in front of you, even if some members wanted more. And I wanted more as well, but this is what we were able to get out in the time that we were asked to get it out. We have a big jurisdiction in our committee. These amendments to the judiciary report do two things. They more narrowly allow for circumstances when a no trespass order could be issued and clarifies what we are asking the Superior Court to study. The feasibility and cost of creating a residential rental docket, not unlike our DUI dockets or our mental health dockets. This would create a rental registry, a residential rental docket. And we're asking the courts to give us guidance on how to reform the process more holistically in the future. On this last point, the Senate Economic Development Committee was able to hear more specifically what the court can deliver and have adjusted the language to reflect that reality. I don't believe Senate Judiciary had the court in to testify. We did, and we worked with them to hone the court study. We appreciate the limitations that the Judiciary Committee made on the House's version of the no trespass section, and we further restricted two sections to make sure people's ability to have guests wasn't unduly infringed. We added a provision that when a guest violates a provision in a lease, that they would have to have a pattern, and that means two or more in violation. So our committee was concerned that if smoking, which is a violation, if smoking was an issue, that they'd have to have established a pattern of having this problem before they moved to evict. And the second was when a guest had been a previous tenant and evicted, they would have had to have been evicted for criminal activity, illegal drug activity, or violence. Very important to us. 3 years ago, our committee heard in this room about the challenges facing Decker Towers in Burlington. Tenants were intimidated, threatened, and scared by guests or formerly evicted tenants. We heard a lot of testimony about the need to support tenants, all tenants, from the impact of criminal activity and drug trafficking that is happening often with criminals preying upon our vulnerable tenants and vulnerable Vermonters. When tenants are preyed upon by others, landlords currently have few tools to support them. As victims, other tenants often feel threatened, and to the extent that they will not speak up. Drug dealing enterprises especially have exploited this loophole in the law, as it allows people to set up their businesses under the safety of someone else's home, which is what we heard a lot about in the Decker Towers case. H772 allows landlords to be their tenants' advocates and rid a property of people taking advantage of them and others by adding specific conditions that allow a property owner to issue a no trespass order. This no trespass provision is equally meaningful to landlords and to tenants, and I will remind you that as we began this work on this bill, that was the objective. Let me review the sections of the bill that our committee amended and passed. So first, we did strike a lot of language from the bill as it came to us. We struck into section 1 entirely, and that addressed a lot of things that we simply did not have the time to really address. And I'll just give you a sampling of some of the things we had to jettison. The cap limiting rent increases, adding definitions of application fee, a cap on security deposits, adding to the prohibited acts to prevent a landlord from retaliating against a tenant, protections to prevent terminating rental agreements. We had to jettison that. We didn't have time to really fully do the work on it that we needed. We also, the second instance of amendment strikes section 1A, which included a lot of things that I would love to have had time to really fully address. This section would have authorized a landlord to bifurcate. This is the bifurcation section. We ended up having a fairly serious disagreement about this, and we'll be able to review it again. But to get the bill out, we had to jettison this as well. And the third instance of amendment we had to strike as well is proposing to strike section 3 in its entirety And this would have removed the provisions of a technical amendment and an amendment that would have allowed a landlord to dispose of a person's personal property, that we had fairly considerable disagreement about that. And the fourth, fifth, and sixth instances of amendment, we propose to make, and we ended up, sorry. So in the fourth, fifth, and sixth instances of amendment, our committee is proposing to make changes to the sections which I have already referred to and that the previous chair has already referred to. In section 5 of the report, the Judiciary Committee is proposing to authorize a landlord to issue no trespass order against a tenant's guests if one of the following conditions are met. The tenant consents to the order, the guests violate the terms of the dwelling unit's lease agreement, the guest violates state or federal law while on the premises, or 4, the guest has previously been ejected from a dwelling unit on the premises due to terminating the rental agreement under the statute. This is the provision of law authorizing landlord to terminate a rental agreement when the tenant breaches the rental agreement by violating its terms or engaging in criminal, illegal, or drug activity or acts of violence. And we supported this. We are proposing to amend this report by requiring in the order, the no trespass order, that there must be a pattern of the terms of the lease, of the pattern of violation of the terms of the lease, and that must not be just one instance, but that there be a pattern of this. The fourth instance of amendment adds in the language to require a pattern of violating the terms. The fifth instance of amendment that we propose to further limit when a landlord can issue a no trespass order against a former tenant who has been previously ejected from a dwelling unit on the premises. The Judiciary Committee proposed to allow a landlord to issue this no trespass order if the individual has previously been ejected. We propose that to only allow this if the individual has been previously ejected under B2, which means that a landlord could issue a no trespass order when the individual has been previously been ejected due to criminal activity, illegal drug activity, and acts of violence. And those are the changes that we made. The seventh instance of amendment, we are proposing to remove sections 7, 8, 9, which were programs that were not funded in the budget. So as they were not funded in the budget, we pulled them out. The eighth instance of amendment is proposing to make changes to the report from the court administration regarding a dedicated residential rental docket. First, we are proposing to add language in subdivision A4 and A5. This language would require that the court include in the report an examination of procedural impacts when an expedited hearing should take place. This was in the Judiciary Committee's report, but has been moved into subdivision A. The change would also require that the court administrator examine whether to include other matters beyond residential rental agreements within the dedicated docket. Second, the committee is proposing to remove what was subsection B from this report. The judiciary testified that requiring them to examine legal issues would not be appropriate given it is a separate branch of government. They didn't want to do policy, they just wanted to examine procedure. So that we clarified that and left all their work procedural and not related to policy. And lastly, the committee is proposing to change what now would be subsection B. The language from the Judiciary Committee required that the court balance the needs of external parties, and this change would instead require that the court administrator consult with external parties. Lastly, we changed the title of the bill and to rename the bill, given the many sections that have been removed from the bill. I would add, we know that these measures are first steps in a long process of improving our landlord-tenant laws. We know that there are growing patterns, that there are growing problems for both tenants and landlords. These issues won't go away, and it's incumbent on us to take at least this first step forward to address the immediate safety needs of tenants and landlords and set forth a process for more systemic changes in the future. We believe H772 moves us forward in a meaningful and responsible way. We heard from 23 witnesses, many of the same that we heard, that the judiciary heard from. We heard from the Wyndham Windsor Housing Trust, the state court administrator, the director of community relations of the Champlain Housing Trust, the director of policy with the Vermont Network Against Domestic and Sexual Violence, the executive director of the Vermont Human Rights Commission, the director of Fair Housing Program in Champlain Valley Office of Economic Opportunity, the ACLU, the two representatives, the chair of House General and the reporter of the bill. We heard from tenant advocates, a retired outreach representative of housing policy, the manager of the Vermont Network, a lobbyist who lobbies for Vermont Association for Justice, the chair of the House Committee, the Vermont Legal Aid, a tenant from Windsor Wyndham Housing Trust, landlord lawyers, two landlord lawyers, and the executive director of the Vermont Landlord Association, the executive director of End Homelessness Vermont, the director of Housing and Homeless Alliance of Vermont, the Vermont Realtors Association, our own terrific and very patient legislative counsel, and an associate with social workers and school counselors, and our own chief superior judge of the Vermont judiciary. The vote to move this bill was 3-2, and we ask the body, the chamber, for your support in these measures. Thank you very much.
I recognize the senator from Franklin, Senator Norris, for the report of the Committee on Appropriations.
Thank you, Mr. President. Senate Appropriations reviewed H772. I got that right. And it can be noted that there's no fiscal note along with it. And so we came to the conclusion this be less than de minimis effect on our budget here in the state of Vermont. So on a vote of 7-0-0, the committee recommends that the bill ought to pass in concurrence with proposals of amendments by the Committee on Judiciary and Economic Development, Housing, and General Affairs. Thank you, Mr. President.
Senator from Wyndham.
Mr. President, would now be the correct time to provide a substitute amendment to the Economic Development Report?
Yes.
Great. Thank you. So, Mr. President, as I mentioned earlier, this substitute amendment, which is being handed out now, restores two of the policies I previously described, specifically the Good Samaritan language and the bifurcation language. This is what was in Section 1 and Section 1A. The amendment also maintains the deletions of sections that were mutually agreed upon by the committees, and those deleted sections are the ones that did not have any real substantive presentation provided. The first instance of amendment returns the Good Samaritan policy and the bifurcation policies located on page 2 of the document that's being handed out. Section 1A, which was included in the judiciary report but struck from the economic development report, will remain, is restored to the bill through this amendment. Section 1A contained the further details on rental agreement bifurcation. The second instance of amendment is for Section 3, which was related to tenant property after eviction. This section remains deleted. On page 3, we have the third instance of amendment, which is the change to the trespass section. As we heard, there were two changes proposed to the trespass section. The first was the insertion of subsection 2 under Title 13, Section 4467B, which was recommended by Economic Development and which Senate Judiciary agrees with. This is the policy that applies to notices against trespass for tenants who were previously ejected for criminal or violent activity. The amendment excludes the pattern of violations language that was previously suggested by Economic Development. Senate Judiciary disagreed with that change, and so it is not included in this amendment. The fourth instance of amendment affects sections 7, 8, and 9, and is related to the positive rental payment credit reporting pilot, security deposits, transition periods, landlord tenant education and technical assistance program, and these sections remain deleted. The fifth instance of amendment adds the housing court study language recommended by Economic Development and strikes the judiciary language. Senate Judiciary agreed with that change. And we heard that correctly that we were not able to hear from the judiciary specifically regarding the court study. We did hear from them a number of times on the other topics, but this study came at the very tail end of our process in judiciary. We wanted to get the bill to Economic Development, and I appreciate the work that they were able to do and the testimony they were able to get from the judiciary to refine the language a bit further. The straw poll in Senate Judiciary on this substitute amendment was 5-0-0, and I ask for the Senate support.
The question is, shall the recommendation of the proposal of amendment of the Committee on Judiciary be amended as recommended by the Committee on Economic Development in general as substituted? That is not the question. Okay. Gotcha. So the question is, shall the report of the Committee on Economic Development be substituted as offered by the senator from Windham? Are you ready for the question? Senator from Rutland.
Thank you, Mr. President. If I may, related to H772, two questions I want to bring forward to the chamber. First is bifurcation. So these are lease splits to protect sexual violence victims. They fundamentally fully get it, fully support that. 90-day protection, okay, I get it, I understand, but the problem that we're facing now is where we have an injured class bumping up against the reality of the landlord who has the obligation and is not relieved from paying their mortgage, which is a monthly cost, paying their utilities, which is a monthly cost, and paying their property taxes, which is typically a quarterly cost. There's no relief for that. So we're bumping into the reality of how do we keep the landlord whole while we're protecting the victim? And that's the rub. And for that reason, I can't support the bifurcation for the 90 days. So that's fundamentally a problem, okay? One problem. Two, that's bifurcation. Second problem, drug overdose protection. We're talking about drugs. We're talking about actively using and abusing illegal drugs. We're talking about substance abuse disorder becoming essentially a tenant-protected class. This shifts the risks to the landlords. Maybe this is okay for a state-subsidized housing agent because we give them, they receive state treasury for construction, big dollars. Sustainment, bigger dollars. My concern is not for them. Maybe they can handle it because we're subsidizing them and they can handle this type of social work recognition. My concern is for mom and pops landlords and their law-abiding tenants. They are not social workers and they should not be mandated to accept this risk. So for these two reasons, while I support the well-thought-out economic development underlying bill, I cannot vote for these two measures, the bifurcation and the drug overdose protection that is in the judiciary amendment. Thank you, Mr. President.
Senator from Wyndham.
Thank you, Mr. President. To the senator's latter point, I believe there's just going to be a difference of opinion on that topic. But to the first point regarding the 90 days, it is incorrect to say that the land board is unable to eject that individual, if that's really what they want to do, after 90 days and seek payment into court for non-payment of rent. So just wanted to clarify that point. Thank you.
Are you ready for the question? Senator from Addison.
Mr. President, I'm confused. I'm wondering if this amendment went through either of the committees and if the committees supported the amendment.
Would you like to interrogate someone?
I guess first the presenter of the amendment.
The presenter of the amendment from Wyndham is interrogated.
Yes, the policies described in this amendment have gone through the committee process. And the goal of this is to essentially restore the judiciary policies that we passed out into this final product. So all of the policies have been discussed at great length, at least in Senate Judiciary.
Okay, so this amendment includes all of the provisions from the Senate Judiciary Amendment. Is that correct?
Yes, it includes, well, no, not quite, because there were provisions in the Senate Judiciary Report which included a long list of economic development policies we didn't touch,
Okay.
but were removed by the Economic Development Committee. The Economic Development Committee also removed 2 judiciary policies and modified 2 other judiciary policies. This amendment returns those 2 removed judiciary policies and accepts some of the modifications to the last 2 judiciary policies.
I see. Okay, and so did this amendment, did the Committee of Judiciary take a straw poll on this amendment?
Yes, it was 5-0-0.
Okay. I thank the presenter, and if I may interrogate the presenter of the economic development.
The reporter of the economic development portion is interrogated.
Thank you.
Did the Committee on Economic Development review this amendment?
We did not. We knew what to expect because we had discussed these elements of the amendment at great length, and our committee was fairly divided over these elements. I'm happy to huddle with my committee, but my feeling is that I will be reporting in a minute or two what I would have reported right now. But I am happy to huddle with my committee in this corner to get a vote on that.
Okay.
Because we have addressed every element of the report during the course of our work. And we, on a vote of 3-2, we actively support the last 2 sections, the no trespass and the court study. And we were, as a committee, very divided over the Good Samaritan and the 90-day piece in the bifurcation.
Okay, I thank the reporter. Mr. President, if I might ask for a recess, I'm very confused about this. My brain has been working on other things this week, and so I'd like to check in with a few people on this. So
We'll take a brief recess.
thank you.
Will the Senate please come to order?
Okay.
Senator from Addison.
Thank you, Mr. President. I'm still confused, but maybe slightly less confused, and I appreciated the time. Thank you.
Senator from Windsor.
Thank you. On a straw poll of 3-2, the Senate Economic Development Committee supports the amendment of the chair of Senate Judiciary.
Are you ready for the question? The question is, shall the report of the Committee on Economic Development be substituted as offered by the senator from Wyndham? Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay.
No.
Division?
Division has been requested. All in favor? Roll call has been requested, and when the vote is taken, it shall be by roll. Are you ready for the question?
Just point of order,
Point of inquiry?
point of inquiry.
What is your point of inquiry?
So we voted on it, so we can call for a division, but we can call for a roll call as a revote?
A roll
as well?
call always trumps a division.
Right, oh.
The secretary shall call the roll.
Senator Baruch?
Yes?
Senator Peck?
No.
Senator Benson?
No.
Senator Baumgart?
Yes.
Senator Brennan?
No.
Senator Brock?
No.
Senator Chittenden?
Yes.
Senator Clarkson?
Yes.
Senator Collingwood?
No.
Senator Cummings?
Yes.
Senator Yulee?
Yes.
Senator Hardy?
Yes.
Senator Harrison?
Yes.
Senator Hashim?
Yes.
Senator Heffernan?
Nay.
Senator Ingle?
No.
Senator Lyons?
Yes.
Senator Major?
Yes.
Senator Matos? Senator Morley?
No.
Senator Norris?
No.
Senator Pershling?
Yes.
Senator Plunkett?
Yes.
Senator Ron Hinsdale?
Yes.
Senator Bohowski?
Yes.
Senator Watson?
Yes.
Senator Weeks?
No.
Senator Westman?
No.
Senator White?
Yes.
Senator Williams?
No.
Senator Matos?
Those voting yes, 17. Those voting no, 12, and the amendment passes. The question now is, shall the recommendation of proposal of amendment of the Committee on Judiciary be amended as recommended by the Committee on Economic Development and General Affairs as substituted by the senator from Wyndham? Senator from Chittenden.
Mr. President, I believe we are now, the question before us is about the substitute amendment from the Committee on Judiciary, and I have a further proposal of amendment I would like to present to that substituted amendment. I ask my colleagues to bear with me on what might be a slightly lengthier explanation than this particular amendment would tend to bear out. I think you heard a little bit of the push and pull on what constitutes good, balanced landlord-tenant law. And I think that really is the crux of where this amendment comes from and where your Committee of Jurisdiction on landlord-tenant law remains divided. Mr. President, we are talking a lot about balance and whether or not there's been balance in this bill for landlords and tenants, whether or not that can be achieved. And I would say we've had landlord-tenant bills or even study reports that come back that in some cases seem tipped in favor of tenants in the past, and we have not, frankly, taken up those recommendations from past study committees. We now have a bill that I will speak for myself, I feel had a lot more voice and testimony from our landlord community, and particularly a lot of folks had in mind some really intense situations that we've talked about in other public safety contexts that tend to erupt more often or be more prominent with our affordable housing providers, our large affordable housing providers. I'm extremely sympathetic to what all housing providers go through in this context. I do want to remind the chamber that our affordable housing providers make up about 15% of who is covered under landlord-tenant law. 85% or a vast majority of landlord-tenant law centers around much smaller, more private, more person-to-person situations. People may have less knowledge of their rights. They may not be income eligible for legal support. There is a balance of power that's really important to visualize and protect. In this case, where one person is at risk of losing their housing and the other person is at risk of losing financial remuneration or losing some kind of financial benefit that they receive from the other person's tenancy. Those are imbalances that are extremely hard to correct. Mr. President, I have said all along with this bill that I didn't want to get up and speak, and I didn't want to be vocal on this bill because I do think it's a bad penny, and I do think this amendment shines it up a little bit. But people look at maybe my last name or my relationship to my spouse, who is a property manager in Burlington for his family's business, and they make an assumption about why I would be silent on landlord-tenant law. But Mr. President, for my entire existence as a legislator and a human being, I've tried to hold the balance of what it means to be on the other side of that agreement, deep, deep in my heart. Mr. President, if you in this chamber, if my colleagues in this chamber have not experienced eviction, foreclosure, or watching their parents sleep in a car during their childhood, it's extremely hard to fully imagine what it can feel like to be on the other end of an agreement where somebody controls your housing. Mr. President, my father also had a disability, and he faced unstable housing, eviction, and the threat of eviction many, many times. If anyone is speaking to you today, it's somebody who spent a childhood dealing a lot with the instability of housing and dealing with that instability as it relates to people in my life who have disabilities. Mr. President, when we look at who ends up homeless, when we look at who ends up unable to defend their rights in a court of law more often than not, or accepts some kind of document because they don't have the financial or other wherewithal to fight that notice, the preponderance, the majority of folks in that situation are people with disabilities. So, Mr. President, while we've heard that there was an attempt to balance landlord and tenant considerations throughout this bill, I would just underscore that you can't give something to landlords in the eviction process and something to tenants in the security deposit process and call that balance. That is actually just not how the balance of landlord-tenant law works. And we heard a characterization, for example, that we had to jettison a cap on rent prices increases or what can be charged for rent up front, a cap on security deposits. I would characterize that differently. What came over to us from the House was a cap on charging an initial deposit from a tenant of 3 times their rent, their first month's rent, their last month's rent, and their security deposit. Mr. President, that is almost non-existent in practice right now because that constitutes an incredible barrier for people to access housing. And if you also haven't faced eviction or foreclosure, you might also not have faced what feels like a growingly insurmountable barrier of even putting that much deposit down or saving up to one day become a homeowner, continually out of reach for folks. So this was not a cap on rent and security deposits. What came to us felt like permission to charge 3 times the first month's rent in order to access housing. A lot of these things were already unlivable for some of us in the bill who've been doing landlord-tenant law for a long time. Mr. President, you also heard, I believe that we had to rush through some things because the landlord-tenant committee of jurisdiction, your Senate Economic Development, Housing and General Affairs Committee was the second to receive this bill. And I agree with that decision. And I agree that a majority of the jurisdiction around this it rests with the Judiciary Committee. And I believe that, Mr. President, because any of us who've been working on landlord-tenant law for a long time feel very strongly that we have needed a landlord-tenant court, what some might call a housing docket, or an eviction diversion program, where people are explained their rights and responsibilities before they lose one of the most critical elements of their life and livelihood to survive, which is their housing. We have municipalities that have smaller landlord-tenant tribunals or panels that deal with security deposit law, et cetera. And each case is extremely unique. And each case rests on figuring out what the right balance of power is in that situation, what the costs, benefits, and risks are in that situation. So I'm extremely supportive of a housing docket moving forward. I think what we've seen, we've talked about the appropriation for this being de minimis. I think in the future, if we are going to get this right, we're going to need to fund our larger affordable housing providers better to provide security, comfort, and safety to all of their tenants. And we're going to need to give more money to the court to do this part of their job. I think when we look at how have these problems erupted, they are not a problem inherent to landlord-tenant agreements. They are not about the letter of the law. They are about a court system that is overwhelmed, where these situations simply do not rise to the same level of threat as many other matters before them. And we've seen in Chittenden County what can happen when you add additional dockets and expedite cases. You get better public safety. What you get with some of the elements of this bill that might carry forward in spirit, unfortunately, Mr. President, is that a dangerous person or somebody who is vulnerable is simply more likely to be back out on the street. And your housing committee also has to think about that, that person might be unduly terrorizing or causing threats to health and safety of other people in that building, but they are still our community members. They are still our Vermonters. And if they get ejected or evicted from one unit, we still do have some obligation, responsibility, and financial commitment to making sure they do not threaten the health and safety of others out in public, as well as some commitment to their own well-being and ability to be rehabilitated. So, Mr. President, the actual amendment, I believe, is a simple and important one to improve the protections for tenants who require an accommodation, request an accommodation, and have a disability. In the section of law that was largely touched by the House that deals with a termination of a rental agreement, and I'm going to use the informal language of mid-course. Landlords reserve their rights to non-renew at this time in every municipality in the state, but this is specific to a termination of the rental agreement before the rental agreement period has ended. And Mr. President, the reason I'm bringing this forward as it relates to things that are still in the bill or no longer in the bill is because we may agree that many landlords, many housing providers are left with no other choice but to no trespass somebody's guests due to patterns of breaching the tenant's rental agreement and particularly due to criminal activity or threats to the health and safety of other tenants. What we should be very careful about, Mr. President, is that that kind of additional power that a landlord has does allow them more control in a imbalanced power situation or over who is allowed to come in and out of their premises, over who is allowed to be in that person's primary dwelling unit. And it very likely allows the landlord to have more access to that person's dwelling unit if they have now the ability to remove somebody from that person's private premises. And so if they have that new right, Mr. President, it is not far-fetched at all to say often people with disabilities end up being the victim of others who might use their property and use their vulnerability for gain and cause them to be in danger of losing their lease agreement, cause them to be seen as the ones breaching their lease, maybe having caused damage in their apartment due to their disability. And that is a new exposure that they will face that I believe needs to be remedied at least in a very specific instance of those who are most vulnerable, not only to the exploitation of others using their apartment, but vulnerable to homelessness and to having their rights go unmet. So, Mr. President, we've heard that we want to streamline our processes. We want to maybe move to evict people faster. Certainly giving the courts the resources to engage in a very individualized understanding of what's happening in a particular landlord-tenant relationship and giving them more resources to make those decisions more quickly is in order. But we have to be very careful when we talk about the idea of overall streamlining evictions, streamlining ejections, streamlining landlord-tenant agreement. I mentioned when we discussed our housing bill yesterday that faster eviction processes, more rights for landlords often invite more capital investment, more private equity, more of a view that this is a resource that can be exploited rather than someone's very fundamental need to remain housed. So, Mr. President, in this termination section regarding mid-course termination of breach of rental agreement, the language simply focuses on those who have a disability and what it already exists to some extent in fair housing law, though the federal government is now moving to dissolve some of the protections related to disability and the ADA in housing law in general. So this becomes more important that the landlord offer that tenant a reasonable accommodation in the case of B1 of what we've been discussing, which is more the damage, the disturbance of the peace that does not result in the threat to health and safety. And the second part, I think some might see as more clarity, that your disability does not protect you, and your request for accommodation does not protect you when there has been violence, criminal activity, or the threat to the health and safety of others, that we should really look separately at those because people with disabilities are not only vulnerable. We heard stories in committee that some thought should get that person ejected or evicted that involve noise disturbances and things like that. And we should be really careful about that, Mr. President. We have not looked at the majority of scenarios in landlord-tenant law in this chamber in order to make careful decisions on that front. And so I ask for this small bit of protection should this bill advance to the governor's signature. Thank you, Mr. President.
Senator from Windsor.
Thank you. We will need to review this amendment, which has changed a bit. And so I would ask that we take a brief recess. Apologies, everybody. And Senate Economic Development, Housing and General Affairs, and anyone else is welcome to come and listen to our legislative council explain the implication of this amendment in the cloakroom. Thank you.
Take a brief recess.
Senate, please come to order. Senator from Windsor.
Thank you very much. I appreciate the senator from Chittenden Southeast efforts to continue to work and hone this issue. I think that the majority, the committee just voted 3-2 to not support this amendment. I have great empathy for the need for us to settle this concern, but we do not have the time to do a thoughtful job on this at this moment. This is why we had to jettison these sections of the bill to do a really good, thoughtful, and balanced job on this. We are going to need more time. And I would encourage this to be addressed next year in next year's session. We have, so I think that is all I will say on this at this moment. To have a balanced proposal next year, I think would be the ideal. And right now, this is one piece at the last minute without a full vetting. So I would ask you to not support this amendment. Thank you.
Are you ready for the question? Senator from Wyndham.
Mr. President, may I interrogate the presenter of the amendment, please?
Presenters interrogated.
Thank you. Mr. President, did the committee receive any testimony regarding this language or similar language?
Yes, Mr. President. I would characterize this as a vetted section with a lot of work on the wording coming from the Coalition to End Homelessness, Vermont Legal Aid, peripherally, the Vermont Tenants Inc., which is called something else now at CVOEO, and the Human Rights Commission all had some hand in drafting the language before you. And in many different iterations, this was reviewed in your Committee on Economic Development, Housing, and General Affairs.
Thank you. And I believe earlier in the presentation, correct me if I'm wrong, but I believe there was a reference to fair housing law and aspects of it that are being dismantled. Could the senator please describe a bit further as to what they were referring to and how this amendment would or wouldn't be related to what is being dismantled?
Thank you for the question, Mr. President. It's something that I tried to absorb in the last 24 hours. So happy to expand on this more, and am grateful to alert my colleagues to this issue through this line of questioning. Mr. President, as I understand it, the Trump administration has a lot of authority it's taking within aspects of the ADA and as it applies to subsidized housing, so programs like Section 8, housing vouchers, et cetera, the jurisdiction of HUD. They are looking, for example, at disallowing service animals as an accommodation for ADA. One of the examples we heard as to oppose this language was somebody who has an anxiety disorder and who makes a lot of noise. I don't want to be too identifying in how I describe this, but they make a lot of noise because of their anxiety disorder. I'm surmising, but for a lot of folks whose disability is related to mental health and anxiety, the removal of service animals from their rights is something that could be likely to cause them to exhibit their symptoms and their anxiety in a way that disturbs the peace of others and could likely get them evicted from their housing.
I thank the senator.
Excuse me, Senator from Wyndham, during the break, several senators and others expressed that they're having trouble hearing you. So if you could please speak up so everyone could hear you.
Noted. Thank you. Mr. President, I'm going to maintain an open mind and see how the rest of the conversation goes, and I will decide how I'm going to vote when we get to that moment in the procedure. Thank you.
Senator from Chittenden.
Thank you, Mr. President. If I might inquire of the presenter of the amendment.
The presenter's interrogated.
So in mind with what the Chair of Economic Development said about process and this coming at the last moment, I find that as I read through the first paragraph here, I do have questions about what various things would mean in practice. But I will ask first, Mr. President, in sentence number 1 of the first paragraph, it says, a landlord shall not terminate a tenancy under subdivision 1 of this subsection if the actions giving reason for the termination are directly related to a tenant's disability. But then in the last sentence of that paragraph, it says if the termination is due in whole or in part to disability-related actions. That, at least on its face, seems like saying two different things, and I'm wondering if the senator can help resolve that for me.
Mr. President, I think this, if I'm understanding the senator's question, I feel like it was a bit incomplete only because if they are sending a notice of termination due in whole or in part to disability, they have to describe the efforts to grant reasonable accommodations that then did not result in a satisfactory outcome for the parties involved that would allow them to keep their housing.
Thank the reporter for that, but the question is really, in that first sentence, it makes it clear that this would only apply to actions that are directly related. But then later on, it seems as though a notice of termination could be based on in whole or in part to disability-related actions. So it seems as though the parallel in the second sentence would be based wholly on disability-related actions, or alternately in the first sentence saying directly or indirectly related. As it is now, it seems contradictory to me the way the language reads.
Mr. President, this is language that has been looked at in many fora by our fair housing law expert in the state, or the person we turn to who has investigatory power in fair housing, which is the executive director of the Human Rights Commission. This was, I want to, if I haven't already, give a lot of thanks to our legislative counsel. Landlord-tenant law involves a lot of areas of the law and is hard to get up to speed on. So this was vetted with multiple attorneys. If the senator would like clarification on if those are somehow contradictory, I would either need to provide that on third reading or take a brief recess.
I thank the senator. Mr. President, I'm not sure that a third reading will satisfy the questions that I have, that being one of them. So I would be seeing this mostly as the chair of economic development saw it. I think it has good intentions behind it, but that paragraph has at least 3 or 4 places where it seems to me there's possibility for confusion in the process. So I will vote no on this with the hope that there will be more sustained testimony and action next session. Thank you, Mr. President.
Senator from Chittenden.
Thank you, Mr. President. I would like to support the pro tem's comments about voting no on this for a number of reasons, and I very much understand and concur with the chair of economic development. There's not time for everything that's embedded within this short piece. ADA requirements, 248 rule requirements. Department of Aging and Independent Living will certainly want to weigh in on this, as will those folks who declare what is or is not a disability. We're using the word here. I would think we're wanting to define it as someone who has been affirmed to have a disability and has support from state and federal government. It's disability in the homeless bill that we passed, the homeless continuum bill, was much broader and much different. We don't want to infer or imply that that definition remains in this as well. So I think there is a lot in this small proposal. Yes, there may be a problem we're trying to solve, but I think it requires the full committee process, and perhaps more than one committee, to evaluate what is actually here. So understood, folks with disabilities are at a disadvantage, no question about it. Many folks with disabilities have certain behavioral expressions that are confusing and also uncomfortable. But this proposal amendment is at the wrong time, and I would hope that we could go back with some broader testimony in the future on it. So I will also not support this proposal at this time. Thank you.
Senator from Essex.
Thank you, Mr. President. I feel a lot like what the senior senator Addison said, confused with a lot of this that's going on. There's just a lot of stuff swirling around. I also feel for the chair of housing of the ones that are bringing this bill forward, that maybe they ran out of time. And with no disrespect, I kind of wonder if maybe that a lot of this is coming out premature, and maybe it should go back to committee so that it could work out, because there seems to be a lot of emotions and division within the committee in itself. And I was wondering if maybe they couldn't take it back in and work out some of their differences. And I get that there's probably some work in here that would really want to get going for this legislative cycle. I just want to make some points out, though, as far as what we're talking about with tenant rights. We have a system that works very, very well already. It's called mortgages. And if you have a mortgage and you're there, and a lot of this doesn't come into play. And I don't know why it needs to be so much different. I don't know why landlords need to be guidance counselors and psychologists if they're providing a place of safety and comfort and doing all the things that they need to do. Providing a place of safe haven for folks to stay, why somebody's emotional or economic or other problems would become their burden. So I have a real hard time understanding it, because we don't have that in the mortgage type system where basically if you pay, you stay, if you don't, you won't. It's no wonder that Airbnbs have been coming and more popular throughout, because we just don't need to go through all of this emotional standoffs where people, for whatever reason, don't have the ability to pay, but do expect that they need to stay there and put the burdens on landlords and themselves. So I would just like to see people be responsible for themselves, knowing full well that people do suffer. But there are a lot of people who are disabled that are in the mortgage systems, and they just don't seem to have these problems at all. I don't know why it needs to be the fault of the landlords for people to be suffering and then come up with excuses for not why they should pay their obligations to somebody who is providing all the services that they were asked to do, but yet there's folks that feel like they shouldn't be compensated for what they have. Thank you, Mr. President.
Senator from Chittenden.
Thank you, Mr. President. First, I'd just like to say there are certain relationships outside of parental relationships or mother-child relationships that are some of the oldest in society. Landlord-tenant, doctor-patient, teacher-student. Most of the other relationships in society are what have made society itself. They are the hallmarks of how we take care of each other and how we treat each other in what we consider a civilized society. So I'd like to also, Mr. President, go back to a more careful reading I was able to do of the language, and would stand by my earlier remarks, Mr. President, that this is actually pretty careful drafting, and you need both end of sentences after the comma of both statements to have them make full sense. per ADA, per accommodation law. Number one, Mr. President, the actions giving reason for the termination are directly related to the tenant's disability. We have to very carefully say directly related, which has some subjectivity built into it, but it's clear to say that there is a direct relationship. These are things that a court of law would be looking at. And the reason there has to be some direct relationship is because then the landlord has to engage in what is clarified in disability law as an interactive process with the tenant, not deciding for them what is related to their disability or not, also not deciding for them what a reasonable accommodation is, but something that's interactive that would enable the tenant to remain housed. Mr. President, it is a separate concept that the termination be due in whole or in part to the disability. That if any part of the termination is due to the disability that the person has conveyed, has communicated, that then the termination notice has to describe the efforts to grant reasonable accommodations. Mr. President, all of these are things that end up being litigated or discussed in our judicial branch because this area of law is so sensitive and it is built upon the other most sensitive area of our law, someone's right to housing and life, liberty, and the pursuit of happiness. So I see them as very carefully crafted to match the second half of each of those statements. And I just wanted to clarify that now that I've had a chance to sit and read it a little more closely again.
Senator from Washington.
Thank you, Mr. President. I think this discussion points out why there is a long tradition in this chamber of not passing floor amendments, even if they sound like something we would like to support, because these are complicated issues. They involve balancing of rights. I am still wondering that if I suffer from PTSD or anxiety disorder, and in order to cope with that, I have developed a substance abuse disorder, which is connected to my disability, but I am also providing a very unpleasant atmosphere for landlords and other tenants. I don't know those those answers. Those are the things that the committee has to have time to weigh and, to come to a decision on. These are very complex issues, and I am just personally not comfortable making a decision up or down when I don't know what the ramifications might be.
Are you ready for the question? The question is, shall the report of the Committee on Economic Development as substituted be amended as offered by the senator from Chittenden Southeast? Are you ready for the question? If so, all in favor say aye.
Aye.
All opposed, nay.
Nay.
The nays have it, and the amendment has failed. The question now is, shall the recommendation of proposal of amendment of the Committee on Judiciary be amended as recommended by the Committee on Economic Development, Housing, and General Affairs as substituted? Are you ready for the question?
Roll call.
Roll call's been requested, and when the vote is taken, it shall be by roll. Are you ready for the question? If so, Secretary shall call the roll.
Mr. President.
Okay. Senator from Madison.
Thank you. Could you just repeat the question? Thank you.
I certainly can. Shall the recommendation of proposal of amendment of the Committee on Judiciary be amended as recommended by the Committee on Economic Development, Housing, and General Affairs as substituted by the senator from Windham? Are you ready for the question? Senator from Chittenden.
Point of inquiry, Mr. President. As we get to this time of year, I wonder if there is a second reading vote after this, or if this is the second reading vote. shall the bill be read a third time?
There are several more questions, Senator.
Okay, if I may withdraw my motion for a roll call then.
We will consider it withdrawn. Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've amended the recommendation of proposal of amendment of the Committee on Judiciary as recommend. Yep. As recommended. The question now is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? Senator from Windsor.
Thank you. As you heard my remarks earlier today, I think this makes meaningful progress on behalf of a very thorny issue, as you now know. I think this adds some important pieces that are reasonably balanced. The no trespass is, I think, very important. I think the court work on creating a residential rental docket is very important. I think Good Samaritan people cannot be punished for calling for help and trying to save their own lives. I think these are important sections and move us, protect our tenants and help our landlords. And I would really encourage us all to help, as you can see, this rather challenging subject of better balancing landlord-tenant law. This helps move us forward in some ways that are quite important. Thank you.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and you've proposed to the House to amend the bill as proposed by the Committee on Judiciary as amended. The question now is, shall the bill be read a third time?
Roll call, Mr. President.
Roll call has been requested, and when the vote is taken, it shall be by roll. Senator from Chittenden.
Mr. President, I feel like I have to say something on this. I am going to vote no on this bill, and I just want to say why. This bill, as I think I caught the pro tem yesterday, is a mess. I don't blame us. I just think that the bill started in the wrong place. I believe in the other chamber, and also when it came over here, this bill started by trying to weigh the rights of disparate groups in completely unrelated circumstances against the rights of completely different groups of tenants in also completely different circumstances. It is a false moral equivalency to say that since we're going to give tenants that have to move because the landlord's going to sell the building 90 days, that it's okay to have tenants that are evicted for one reason or another only 5 days as opposed to 15 days, and simultaneously have, when the writ of possession occurs, the landlord can then eject all of their belongings to the curb immediately. There were multiple aspects of this bill that just didn't feel right. They didn't feel right to me, and it felt really wrong to be presented as giving this group of tenants, taking away from this completely other group of tenants is somehow going to be okay. I just think this was the wrong way to approach this very complex and thorny topic of landlord-tenant law, and I hope that the next legislature takes these things on merit. For each individual thing you're considering, is this the right thing? Does this make sense for that group? And recognizing that you can't weigh the balance of giving up rights for these tenants just because you're giving rights to completely separate tenants elsewhere. So I'm a no on this bill, and I hope the next legislature does take a different approach from the start on tackling this topic. Thank you, Mr. President.
Are you ready for the question? Senator from Windham.
Just going to clarify that there's nothing in the bill as amended that leads to a landlord just placing all of a person's property on the side of the road. As I've mentioned earlier, a lot was taken out of this bill to focus on several narrow provisions that do provide protections to tenants, and the no trespass, which could be advantageous to both landlords and other tenants who may be getting impacted by some of the challenges that we're hearing about. So I'll be voting yes on this.
Senator from Chittenden.
Mr. President, I just want to completely state clearly that part of what we stripped out of this bill did have a writ of possession occur so that the possessions could be ejected to the curb much more quickly. My point is there's still the opportunity for a committee of conference and for that language to come back. And so even then, that's why I'm still a no on this bill, because I think too much of this bill is a mess. And it was just the wrong approach from the beginning. So that's what I'd say, Mr. President.
Are you ready for the question? If so, the secretary shall call the roll.
Senator Baruch.
Yes?
Senator Fett.
No.
Senator Benson.
No.
Senator Bongo.
Yes.
Senator Brennan.
No.
Senator Brock.
No.
Senator Chittenden.
No.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Dooley.
Yes.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hashim.
Yes.
Senator Heffernan.
Nay.
Senator Engel.
No.
Senator Lyon.
Yes.
Senator Major.
Yes.
Senator Matto.
No.
Senator Morley.
No.
Senator Norris.
No.
Senator Pershling.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
No.
Senator Bohosky.
No.
Senator Watson.
Yes.
Senator Weeks.
No.
Senator Weston.
No.
Senator White.
Yes.
Senator Williams.
No.
Senator Collmore. How do you vote?
I voted yes, Mr. President.
What'd you get? That's what I got. Tie. So those voting in favor, 15, those voting against, 15, and the Lieutenant Governor votes no. Senator from Chittenden.
I believe our actions are complete on that bill, Mr. President.
Yes.
With that said, I would ask that pending announcements, Senate stand in adjournment until 2:30 this afternoon.
Are there any announcements? Senator from Wyndham.
Thank you, Mr. President. Senate institutions will meet at 1.
Senator from Chittenden.
Thank you, Mr. President. Senate Health and Welfare will meet at the fall of the gavel after the next session at 2:30. We'll see what time we have. Thank you, Mr. President.
Are there any further announcements? Senator from Windsor.
Thank you. The conference committee on H639 will meet at 12:30. Get your lunch and come join us in Senate Economic Development. Thank you.
Are there any further announcements? Seeing none, the senator from Chittenden Central has moved that the Senate stand in adjournment until 2:30 this afternoon. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we'll stand in adjournment until 2:30 this afternoon.